Good afternoon. Let me just say thank you for letting me come and speak today in support of this ordinance, and I'll tell you why. The reason became very clear on February 16th of this year, because I thought simply going to an establishment in my neighborhood and less than a mile from my house when I'm a sitting state district judge would be just an inconsequential thing, especially when going out with one of my colleagues in the state house as well. As State Representative Armando Wally was with me, and we walked upon an establishment in my neighborhood on Washington Avenue, walked up to the door and asked to be let in, and actually we didn't even get to ask to be let in. Upon walking up, we were told, you don't have reservations. In 2014, a tactic used, I'm sure, on my parents and everyone else's parents in here that have gone through the same struggles was used on me. It is absurd that a place like the Roosevelt, which I'm sure you all have heard of, all of their problems, they are not in existence as of today, but on February 16th of this year they were. And they denied me access and a state representative access. And after several choice words and trying to understand how a bar and not a restaurant was somehow living by a reservations-only code, and only one person could give you a reservation, and that person had no intention of ever giving me or my colleague a reservation, tells you this ordinance needs to be there.
Thank you, Judge. Councilmember, wait a minute. Councilmember Green.
Thank you, Madam Chair. Judge, if you'd like to finish your statement.
My point is, as we were standing in this parking lot trying to figure out how to help the next person that might want to go to that establishment that might get denied simply for the color of their skin, how they look, anything, we had no recourse. You pass this ordinance or some version thereof, and we have recourse.
Councilmember Boykins.
Judge, thank you for coming down. I'm sorry to see you on crutches. Is that what they did to you on Washington Avenue?
I would love that to be part of the story, but alas, no.
Well, I just want to say we've heard, during committee hearings, and they keep referring to Washington Avenue, and I just want to say all of your friends and folk who are having problems on Washington, tell them in District D we will welcome them. Bring that money over to District D. We will welcome their spending in our district. You have no problem spending your money in District D. Thank you for coming.
Councilmember, I'd like to take privilege of the chair to mention that one bad apple does not discredit an entire street.
I know,
and with Washington Avenue being in District C, thank you so much. Next,
I still have my minute, Madam Chair. But the 50 that was turned down at that one bad apple, we'll take those, okay?
Councilmember Laster.
Judge, I guess I could follow up on my colleague's invitation. You're always welcome in District J in Southwest Houston.
I'm not sure some people of Southwest Houston want me to be around. So.
All of us in Southwest Houston want you to be there because we all want to be there, and I want you to know that you're always welcome in District J.
Thank you.
But Judge, let me just say this to you. There are many, many people in this city who cannot be here today that have experienced something like you have experienced. And I just want to thank you for putting a human face to this issue. Thank you, and God bless.
Welcome.
Councilmember Bradford.
Thank you, Madam Chair. Your Honor, isn't there already provisos on the books to address what you encountered on Washington?
No, sadly, as we stood there in that parking lot trying to figure out, is there anything that we can do immediately?
Okay.
Immediately to see recourse, and there's nothing.
In your opinion, you were rejected for what reason?
The color of our skin. That was it. And it was made very, very apparent. There was no bones about it.
Okay.
And even after letting them know who we were, still nothing.
So in federal and state statutes don't address that already?
Not for the type of business that it was. And not for that instance. That doesn't give me recourse. That business, short of the fact that they had other issues as well, could still be operating today. And have had no recourse. There would be no punishment against them for denying me access, denying access to several. I'm not the only one. I don't think I'm the only one that was denied access at that location. I know there are several that were denied access. In fact, several of those have instituted civil lawsuits in Harris County because they could not get any recourse. And if this just gives just that much to tell an owner of a business that you shouldn't discriminate against anybody, then I'm okay with that, and I can support that.
Thank you, Your Honor. I yield.
Thank you, Councilmember Green.
Thank you, Judge. And just to follow up with Councilmember Bradford, the recourse, I think, would actually be to file civil litigation, either Section 1983 if we did federal, or whether or not there was a state issue with regard to discrimination. But my question to Attorney Feldman is, in this particular instance, if she were to come and file under the proposed ordinance, would we hear her claim, or would we refer her to civil court?
No.
Or the court, or
in no event would we refer anybody to civil court. No, we would hear, this is public accommodations. We would not be referring that to any other agency, because the only other agency would be the U.S. Department of Justice. There is no state agency that deals with this. There is no state law that protects citizens in this regard, not in Texas. So it's either the city or it's the federal government, and that's the U.S. Department of Justice.
Or litigation.
And you would have to sue under the Civil Rights Act.
Right.
In federal court.
Right. Okay. Thank you.
Thank you very much, Judge, and I hope you heal soon.
Thank you.